And let's not forget, Judge, that when Trayvon Martin was known to have been running away from George Zimmerman was still in his car. Ms. Gentile corroborated that at the time the second to last call disconnected is when she told Trayvon Martin to run, and he did. Because the next time she talked with him, he told her that he had lost the man. The reconnect time was about 20 seconds. And then they stayed on the phone for the next 3 or 3.5 minutes. In the meantime, George Zimmerman is on the phone for a good bit of that time with the police. So, what we know from that in and of itself is that Trayvon Martin had 2 or 3 minutes to get home 348 feet. He had 2 or 3 or maybe 4 minutes to do that and chose not to. He decided either to go home and come back, or that he decided to hang around and wait for George Zimmerman to get off the phone so he could confront George Zimmerman and ask him whatever he said, why you follow me, or man, what's your problem, whatever that was, he said he's the one that initiated it. That's clear from Ms. Gentile and, frankly, any other evidence that's in this case. We know that happened from the physical evidence as well as the circumstantial evidence, which, as we know, is just as good as direct evidence, according to Mr. Delarianda. So that's established clearly. There was no pursuit. You heard the call. Mr. Zimmerman said, when he was told, we don't need you to do that, okay. And he was on the phone for another, what, minute or so? We know where the event took place. It started at the T. George Zimmerman's key with the flashlight was found right there, the one he had in his hand on his way back to the car, in the direction of the car, thinking that the police were going to arrive any minute. It is outrageous to suggest that there is sufficient evidence to offer to this jury that George Zimmerman provoked this incident. Because what the law requires in order to have provoked this incident is proof that there was the use of force, the actual use of force, or the threatened use of force. Walking up to somebody, following somebody, is not enough to get you to the legal definition of provoke. That's the Gibbs case. It's absolutely clear where the court committed reversible error by not saying that, if you will, in its instructions. Mr. Mantine knows that case. There's no legal issue, as that's what provoked means. And for him to say that George Zimmerman followed Trayvon Martin is a legally supportable basis to claim that he provoked the violence that Trayvon Martin used against him is disingenuous and legally incorrect. He knows that, and he knows better than that to try to convince the court. So I have the Gibbs law, case law. The court knows how that works, and the state has not offered a compelling argument supported with facts or the law why the court should introduce this issue to the jury and make them even consider that George Zimmerman may have provoked this.